Hello, Jeff M. Brown, legal writer with the State Bar of Wisconsin, here at the annual meeting and conference at the Grand Geneva Resort in Lake Geneva. Happy to be back in person again after 3 years. I am here with Judge Joseph Donald from the District 1 Court of Appeals to talk about the nuts and bolts of appellate practice. Judge, welcome.
Well, thank you, Jeff. It's a pleasure to be with you.
Yeah, good to be back in person. You were a trial judge before you were on the Court of Appeals.
For 23 years.
Tell me, what are some of the differences that you've noticed being trial versus Court of Appeals, and which one do you prefer more?
Well, now that I'm on the appellate court, I realize as a trial court judge how much discretion I had, and in terms of making decisions. As an appellate court judge, I'm very limited in terms of what sort of discretionary decisions, and so that's probably one of the things that I miss. The other aspect of the job that I wasn't quite ready to prepare for, but now I understand why, is sort of the collaborative process in getting a decision out. So it isn't just what I think it should be. I have two colleagues that I need to make sure are in agreement, and so that took a little bit of adjustment, but I'm liking it.
How does that process work at the Court of Appeals? I mean, do you guys have regular conferences on cases where you kind of chew them over, or?
Well, we schedule in District 1, we have 4 panels, 6 cases on a panel. We're responsible for 18 cases, and then we pick, usually it's the first Tuesday of the month, our screening day, and we get together in the conference room, and we just go through. Panel 1 goes through its 6 cases, and then we'll rotate a judge in, and then panel 2, and then so forth. And as I tried to explain today to the participants here, it really is just a conversation. Mm-hmm. It's sitting down and talking about the case, and then deciding, where you are on it. Are you going to affirm? Do you think it needs to be reversed? Are you going to dissent, concur? So it's just that kind of collaborative process of working through it with your colleagues.
Do you trade opinions back and forth, or is there not much of that at Court of Appeals?
And when you mean trade, do like horse trading?
Well, no, shared drafts. Circulating drafts.
Yes. So there is a draft. If you are assigned, it's assigned to your chambers, you're the judge who's assigned to write that opinion, then you draft the opinion. And then it goes from the draft to circulating the draft, where other judges get to comment, make suggestions. Sometimes suggestions are necessarily with respect to substantive issues, just style issues. And sometimes, so that's kind of a negotiation, give and take. If it's a real substantive issue, if you make too many changes, then you may lose, your colleagues in terms of how the case should be handled. But yes, so we do circulate those cases.
What are some common mistakes that you see in appellate briefs?
I would say probably failing to raise the issue in the trial court. So they either didn't make the objection, or they didn't address it either in, say, a motion in limine, or they, and so the forfeiture or waiver, those are
which are different things, as a recent opinion pointed out.
Right, those are different things, but those are the common ones. Yeah.
And in the CLE that we just came out of, you talked a lot about make the record, the record, and this is related to the...
Make the record, right, because, we are not a fact-finding court. So, so that oftentimes when I will see issues or decisions that are made, as I pointed out, one of my sort of pet peeves are off-the-record discussions. There's no problem. I know as a trial judge, it's necessary to kind of handle some things off the record, but when you go back on the record, there should be a summary of what happened, why it happened. So at least if you want to preserve that issue for appeal. Otherwise, if it's not on the record, we can't address it.
It's the undiscovered country, to quote Hamlet, right? I mean, you talk about the four corners of a contract. This seems like it's a landscape, and that kind of conversation, if it's not memorialized on the record, is beyond a border and is undiscovered.
We can't touch it. Can't touch it.
What do you wish appellate lawyers knew that they maybe don't know about the appellate process and the decision-making process?
Well, they don't know who's assigned to their panel, and I think that it's important to understand who your audience is when you're writing to them. And so my suggestion often is to sort of do a little background search on the appellate judges. Who there's only 16 of us, and there's a lot of information out there about who we are, where we went to school, what our background, what our life stories are. Those are little clues, in my opinion, may give you some insight into how they might approach a particular issue.
You might craft a brief differently if you're writing to a former district court judge as opposed to someone who came out of a corporate legal department.
Exactly.
Last question, and it's a bit of a more serious one. We meet, a couple weeks after Judge Romer was killed in a targeted attack. Retired Judge Romer.
Yes.
The Chief Justice talked about that today before the morning plenary. Judicial security's always been an issue, as she pointed out, but now really an issue after that. How are you dealing with that? How are you coping with that?
Well, the first thing I did after hearing about Judge Romer was to reassure my family, because when something is in the news like that, everyone is worried.
Sure.
And so I told them, look, we have security training. They do a really good job of making sure that we understand how important it is. I think, in my estimation, it's an attack on judicial independence. It's like, well, wait a minute. If we can't, if the judges cannot enforce the law and they are subject to, random retribution by, people out there, that affects judicial independence and undermines one of the tenets and foundations of our country.
Does your experience as a trial judge, because Judge Romer was a trial judge, and this was apparently someone who had appeared before him, I don't remember how long, but it was 5, 10, maybe 15 years before. How does your experience as a trial judge inform the way you think about that?
Well, it's funny. When I was on the trial bench, I did receive my share of bizarre letters that could be threats, some that were threats that were not particularly realistic, but yet still, again, threats. I would always refer those to our chief judge and the sheriff. They would be investigated, and so it did happen, and it does still happen. So I think what is required, however, is that we ensure that if there is that threat out there, that it is appropriately investigated.
Yeah. Okay. Wonderful, Judge Dunlop. Thank you for your time today. Good to meet you.
Real pleasure.
Okay.
Thank you.